would very much welcome your questions during the discussion. Before we launch into the discussion, though, I just wanted to take my moderator's prerogative just briefly to rebut, if you will, a couple of the statements by Tom and Susan and by David. It is true that many of the cases that have been brought and settled in this area have involved alleged or even proven false or misleading statements, but not every investigation and not every case does involve false or misleading statements. There are numerous investigations and cases that involve truthful off-label statements, the right-hand box that I referred to earlier, and I think it is critically important to keep that in mind. And it is that fact that drives the defense bar's passion here. The government was very expressive and passionate in its beliefs that false or misleading statements need to be addressed either criminally or civilly. The manufacturer's perspective is equally passionate that truthful, non-misleading statements that can benefit the health of patients should not be prosecuted criminally or civilly, and indeed, as we'll talk about in a minute, may in fact be protected by the First Amendment to the Constitution. So with that backdrop, Susan, if I could perhaps start with you here. We started, Kirsten started off by talking about the fundamental prohibitions in the Food, Drug, and Cosmetic Act that, at least colloquially, are understood to prohibit certain forms of promotional conduct, if you will. And on the other hand, she pointed out that by regulation or by policy, there are various forms of communication that the FDA permits, so-called scientific exchange, the dissemination of reprints, support for CME, responding to unsolicited questions by doctors and the like. In a kind of loose sense, I tend to divide the world into promotion versus non-promotion, or promotion versus education. And I don't believe that educational statements can give rise to criminal or civil liability. I wonder if you could address your perspective on whether there is a divide, and if so, where that line is.
The devil's always in the details in these questions. You know, there are certain exceptions in the Food, Drug, and Cosmetic Act, and you will not see a case that's brought solely on distribution of peer-reviewed literature, assuming that peer-reviewed literature doesn't contain false and misleading statements, or just unsolicited responses to a physician's request for information. What we actually see, and the reason I have trouble with Paul's question, is pharmaceutical manufacturers who, for example, blast out responses to physician information requests, which are sham requests. They never existed to start with. Representatives who walk around and hand them out, regardless of whether a physician asks for them or not. Continuing medical education that is supposedly independent, but we learn in the course of the investigation was set up, controlled, the speaker picked, the subject matter discussed, the slides in fact created in part by the pharmaceutical company, and that passes as continuing medical education that's independent. Peer-reviewed journal articles, which should be able for our doctors to rely on them when they pick up the New England Journal of Medicine or the internal annals of what?
Annals of
Internal Medicine. And those articles should be accurate. But it again depends on if you've had, for example, a pharmaceutical company that has ghost-written the article, left out significant information out of that article, only put in what they wanted someone to see, suppress the negative information, then the article itself doesn't contain truthful, non-misleading speech. So, Paul, I have trouble at the foundation of the question because inevitably we're looking under the question of if it was true that something was an unsolicited response to A doctor asked a question, and the pharmaceutical representative called medical information back at pharmaceutical headquarters, and they gave truthful, non-misleading speech to that doctor about it. We wouldn't be interested in that. We wouldn't be interested in true scientific exchange. That's what's supposed to happen out there. What concerns us as prosecutors, and I know you say that there are cases out there that involve truthful, non-misleading speech. I don't know of them. I don't know of those investigations. And I know when we don't have endless resources. We're trying to clean up an industry. So from our perspective, it's to pick the bad ones and to pursue those things that will deter other people from doing the same.
Kristen, I suspect you have a somewhat different perspective.
I do, but I think part of it too is it's difficult because when what you hear is really examples of the worst, it's too easy to think that these lines are really black and white. As a starting point, I'd like to just sort of ground us in the regulation that has really triggered a lot of this discussion. When I went through the introduction, I mentioned that a lot of the things, including the recent guidance on reprints, has that black box warning that this is not legally binding on FDA or anyone else. Well, there is a regulation that the Food Drug and that the FDA has created. It's been out there for a long time. It's specifically in the context of investigational new drug applications, but FDA has recognized it applies more generally. And the basic statement is that while a sponsor shall not represent in a promotional context that a new drug is safe or effective for an investigational purpose, this is not intended to restrict the full exchange of scientific information concerning the drug, including dissemination of scientific findings in scientific or lay media. The intent is to restrict promotional claims, not full scientific exchange. I think as a starting point for understanding the promotional versus scientific exchange discussion, need to do two things. Number one, focus on the fact that the line that we need to draw here is a line that is within the kind of conduct that you could expect a for-profit pharmaceutical company to engage in, which means when you're trying to decide what is promotional context and what is true scientific exchange, you're not comparing what a pharmaceutical company does to what a wholly independent academic medical center might do with no pharmaceutical involvement whatsoever. You're comparing scientific speech by a pharmaceutical manufacturer to promotional speech by a pharmaceutical manufacturer. It matters that this is a for-profit company. Even when a pharmaceutical company is making decisions about what scientific research to fund, how to conduct that research, how to publish it, and how to communicate about it to customers and to the scientific community, this is a for-profit company. And so there will be discussion within the company of the business impact of all of those decisions. That doesn't render those communications any less scientific, and it doesn't turn everything that the pharmaceutical company does into a promotional statement. So for example, if you have discussion within a company about whether to pursue scientific research on an unapproved use for FDA approval, or whether just to perhaps stop with the research at a phase 1 or phase 2 level, there's going to be discussion within the company about the financial cost benefit of pursuing a registrational study. That doesn't mean that everything that comes out of this, or a decision not to pursue registrational study, all of a sudden is all promotional communications. So the line between promotion and scientific exchange has to be drawn with an understanding that it is a for-profit company that's going to be making the scientific communications. I think the second thing to keep in mind when we're talking about the public health policy considerations that Paul and Susan and Tom and David have all raised is that you can't have disclosures by pharmaceutical companies about new and emerging uses of off-label uses of drugs that benefit the public health without also allowing that there are going to be disclosures about emerging off-label uses that turn out, at the end of the day, not to be efficacious or even potentially harmful. So if you're willing as a policy matter and as a, to allow that it is a good thing for public health that we get early disclosure in advance of FDA approval of research on new uses, because that could really reveal a lot of information that physicians can then use to prescribe these emerging and successful therapies that we're going to have to tolerate the fact that there's going to be scientific research that's published that ultimately ends up being proven wrong when the more, adequately controlled and larger scientific studies are eventually done involving the research. So the measure for whether, for whether off-label promotional speech should be allowed isn't, and whether speech from a company about its scientific research should be allowed, isn't ultimately necessarily whether that research, will always prove to be research about a new successful therapy. In terms of how this plays out in practice, I think that it's important to think about some things. This is where I'd love to get some feedback from from Tom and David and Paul on this. Is that when we're analyzing it, and when you've heard some of the facts discussed here, there are certain types of things that the government and manufacturers are looking at when they're trying to figure out how to draw these lines in the area. And I think that one of the things where there's very little actual legal guidance is on what weight should be given to these factors. If the key question is, how do we determine whether it's a promotional context rather than a scientific exchange or an educational context, we need to answer some questions. What role does who the speaker is play? This may seem like an easy question. You've heard Susan and Tom point out to, the fact that sales representatives are sort of a classic speaker that you would think of as someone who speaks in a promotional context. What if they're with a medical liaison? Does the fact that the medical liaison is with a promotional speaker, a sales representative, turn the entire interaction into a promotional communication, or can the same meeting have both a promotional and a non-promotional content? I don't think that, I think these are legitimate questions that companies are really struggling with. And it's easy to say that it's all obviously promotional and not scientific, but in practice it's not always clear that that's the case.
These are the doctors that we very kindly refer to them on our side as doctors for a day. The doctors who make $500,000, $600,000, $800,000 a year to accompany sales representatives to the physician offices to sell drugs. Could there be a circumstance where a doctor's talking to another doctor and it's true scientific exchange? Sure. If a pharmaceutical company is lining their pockets to go in and present a particular point of view, at least from our perspective, that's a different animal. So,
there are a couple of very interesting points laid out very articulately. One is this critical point that I addressed. Is there a distinction between promotion and scientific exchange? And if so, where is that line? And does the payment by a manufacturer to a physician negate or blur that line? I want to pursue for a moment the other issue that Kirsten, actually both Kirsten and Susan raised about truthful or untruthful, false or not false. We are at the end of the day in this circumstance talking about scientific information, about the results of clinical trials. Let's leave aside, for purposes of this discussion, the situation in which a manufacturer hypothetically fails to disclose the results of some trial. I want to take that issue off the table for a moment, because that's the easier question. But if, which is not to say that it doesn't happen, but that's not the question on which I want to focus. I want to ask a different question, which is this. We have all come to appreciate that the FDA requires a very high level of proof in order to permit a manufacturer to make a particular claim on a label, on a drug label. There have to, as a general matter, be two large randomized controlled clinical trials comparing the drug to placebo. But there are an infinite array of other kinds of trials out there, phase 1 trials, phase 2 trials, which are less rigorous, don't give you information that is quite as definitive, maybe suggestive of a particular result. Manufacturers, historically at least, have frequently disseminated or supported the dissemination of let's call them early stage trials. Susan, question to you: are those inherently false or misleading? I mean, if the study design is presented if the limitations of the study are obvious from the face of the study, what's false or misleading, even though they're not definitive?
Go right ahead. I'm deferring to my colleague.
Yeah,
Really
or Tom.
wants this
I
one.
asked if I could take that because I like to deal with facts. These phase 1, phase 2, phase 3 trials. Phase 1 trials are on healthy subjects. Phase 2 trials are on a small group of subjects that have the disease that you want to study. Phase 3 are the double-blind, randomized controlled trials that you're going to submit to the FDA. I mean, all of these get submitted to the FDA, but they are the ones that get submitted to the FDA. And the numbers don't have to be that big. Some of the Neurontin trials were under 100 subjects, and they got approval. So Paul asked, I think you asked, is there anything false and misleading about these trials? So let's talk about facts. Because in Neurontin, what we saw is we saw rigged trials. We saw the design of a trial designed in such a way as to get a favorable outcome. And they knew it. And what I'm referring to is a forced titration study. And forced titration means you got your study group, right? The guys that get Neurontin, and then you've got your placebo group. And the ones that were getting Neurontin, they were forcing the titration, meaning the dosage up, 300 milligrams, 600 milligrams next week, 900, and so on, until they experienced side effects. Once they got side effects, they had the effect of unblinding the trial. And you know when we say double blind, it means the patient doesn't know what he's getting and the doctor doesn't know what he's giving. But once a trial becomes unblinded, then there can be bias injected into that, and it's not considered scientific because of the placebo effect. Once you think you're getting a drug, then you can have some improvement. And so that's not a scientific trial. The FDA won't accept an open label trial unless you have several double-blind placebo-controlled trials. So, Paul, in response to your question, yes, we saw these rigged trials, forced titration trials, so the patients knew they were getting Neurontin because they experienced side effects, dizziness, and then what would happen is they titrate them back down. But once the trial becomes unblinded, it is unreliable. And the internal emails of the company discussed this fact, that it had an unblinding effect. And they did an ALS trial prior to this, and they were aware of the unblinding effect on it, and that it destroys the reliability of it. And that trial for DPN was submitted to JAMA. It was their flagship study for Neurontin for diabetic peripheral neuropathy. It was not an approved use. And it got written up in JAMA. And they took that article and they sent it to 300,000 physicians across the United States. And they built a publicity campaign around that JAMA article that had 85 million media impressions. News, TV, videos on airplanes, all the journal articles. And with regard to that article, they said in the article it was the first time Neurontin was studied for diabetic peripheral neuropathy, for pain from that condition. And that was a false statement because Dr. Gorson had been paid by that company to study it at the St. Elizabeth's Hospital in Boston, and he had a small double-blind placebo-controlled trial in which he found placebo was more effective. He sent the results to them, and they held back on that, and they came forward and put that article out in JAMA, which was another study they had paid for, and they built that campaign around it. And where did Dr. Gorson's article show up? Did that become a reprint that the company circulated to the medical profession? Did that article get 85 million impressions? It was a letter to the editor that Dr. Gorson wrote. That's how that got treated. Never got disclosed at any of the so-called independent CMEs. So, you know, we want to talk about, as Susan said, facts, and we feel strongly about them.
Paul, can I get a shot? Can the state guy in the corner get a shot?
David, let me
Right.
pose a question to you, David. As you can see, this is an issue that generates a great deal of interest and passion. Again, I want to take off the table for the moment the situation where an article, fails, where some article is suppressed. But let me ask this question to you, David. let's accept that some studies are poorly designed, okay? It just happens. Not every study is perfectly designed. If the methodology is disclosed, okay, is that false and misleading under your consumer protection statute?
Well, first of all, you asked before about phase 2 studies, smaller studies that are not statistically powered to demonstrate efficacy. Their purpose is basically to establish sufficient safety that a larger phase 3 study can be conducted. So the question is, if you use a phase 2 study to try to demonstrate efficacy, is that inherently misleading? Yes, because there is no basis, there's no statistical significance to a finding regarding efficacy.
David,
Now,
yep, go ahead.
I know we like to think about physicians as omniscient and all-knowing and highly versed in analyzing statistical studies. I have doctors in my family. I've worked in healthcare for over 20 years. I can tell you that many doctors don't know what a p-value is, all right? Many doctors don't know what a confidence interval is. With the Neurontin money that the states received, we're spending $20 million to train doctors to better use evidence-based medicine, and it is increasingly finding itself in medical school curriculums. That said, unless there was a clear disclosure that this small phase 2 study is not evidence of efficacy, that it is not statistically powered to demonstrate efficacy, then yes, I think it would be misleading. So in answer to your question, I think a certain amount of disclosure is necessary when sharing these scientific studies.
This is a really nice segue into one of the other issues that we wanted to discuss, which is the constitutional dimension to all of this. Inherent, and I have learned, David, never to put words in your mouth, but inherent in what you just said is, quite frankly, a somewhat paternalistic notion that because physicians don't have the time, don't necessarily have perfect training to evaluate the statistics of a particular study, that it is the state's obligation to suppress, frankly, that information, to either penalize the distribution of it or, in some cases, potentially to criminalize that. And I'd like to invite a dialogue here about whether that is permitted under the First Amendment. Isn't the essence of the First Amendment and its counterpart in the states that our system is founded, particularly when we're talking about scientific discussion, and frankly, science is often wrong. And one of the reasons that science is afforded the highest level of protection under the First Amendment is that it's inherently self-correcting. If you say, X works, and someone else tries it and X doesn't work, they publish that and that's corrected. Help me understand here how your perspective is consistent with the notion that constitutionally we generally view more speech as better than less speech.
No one's talking about suppressing
Well,
information.
I think if you penalize the distribution of a phase 2 trial because it's inherently misleading, to me that's suppression.
Phase 2 trials are often published. Thankfully, now their results must be posted in the NIH data set. It is not a question of suppressing information. And I think it's almost ironic because the facts of our cases is, though you might want to take it off the table, that for these off-label promotions, then it has often been the case that the positive study is disseminated and the negative study is no one mentions. And maybe it's not even totally suppressed, but it is not disseminated. Let me give you a good example of that is in our recent Bextra case. Now, in this case, and these are all our allegations, so let me preface everything as an allegation because there was a stipulated settlement with no admission of wrongdoing. After Pfizer new drug application seeking an indication for acute and perioperative pain for Bextra was denied, in large part based upon a study, I'll call it Cabbage 1. It was for coronary bypass graft surgery, which showed a statistically significant doubling of serious adverse events, including death, for patients who took the drug. And Pfizer said, no, this was a fluke. FDA, we think it's a fluke. And they said, well, if you think it's a fluke, go do a second study and prove us that we're wrong. We allege that they went forth and disseminated hundreds of thousands of copies of their positive studies from the NDA, but not a single study of the negative study that was the basis for the rejection. That wasn't hidden. I mean, you could go out there and find the information if you wanted to dig. However, what's the balance of having hundreds of thousands of copies of the positive study given to every doctor in America who prescribes for the off-label indication, yet failing to balance that with the negative study that was the basis for the denial? I might add, when the second study was done, it confirmed FDA's concerns and the drug was pulled. So that's the scenario I would like you to address, Paul, where the company is disseminating one study, but not the other. But it's not hidden. It's out there. But do their reps have an obligation to balance the positive study with the negative study?
I think physicians have an obligation before they treat a patient, particularly with a drug that's dangerous, to understand the implications of what they are doing. I think that's the bottom line here. I want to make one other point about Bextra and then invite Kirsten's viewpoint on First Amendment. There is a case actually involving Bextra, a case brought under the California Consumer Protection Code 17200, in which Pharmacia was sued for allegedly off-label promoting Bextra, and the evidence in that particular case was the dissemination of 2 articles that had been published in the Journal of the American Dental Association. And to its great credit, a California court dismissed that case on First Amendment grounds, saying that, appropriately in my view, that the use in this context of a peer-reviewed journal article was a constitutionally protected act, and that liability could not be imposed on the company for disseminating peer-reviewed scientific literature. Kirsten, your perspective on this First Amendment issue.
Sure. I think, not surprisingly, I'm more closely aligned with Paul on this one. But I think it's important, as we see the back and forth in the discussion here, that when a question is put to our respective colleagues over here about some of the more challenging questions, like, for example, would dissemination of a phase 2 study, in and of itself be a criminal violation because it isn't powered to meet the effectiveness definition that FDA requires for FDA approval. And the answer is to say, well, let me tell you about what happened in Bextra, where the situation is very different from that. The situation is where you have a study that's been disclosed and a negative study that has not been affirmatively disclosed along with it. So I think, the difficulty here is, and similarly when Susan was talking about kind of prototypical examples of the kind of cases that really drive the passion of prosecutors here, focused on cases where patients suffered harm from the off-label use that was in question. Companies have been prosecuted and have pled guilty and have paid astronomical criminal fines in cases where their drugs absolutely did not cause harm, and in fact where they later got FDA approval for the exact same indications that they were prosecuted for, pled guilty for promoting, and paid criminal fines for promoting. So it's not the case that the government is only going after instances where harmful off-label uses have been promoted. And I think the reason for this is not that the government is acting in bad faith in any way, shape, or form. It's because the law doesn't draw that distinction, and it's really hard to tell in advance whether at the end of the day this is something that's going to get FDA approval or not. And that's where I think the First Amendment comes in, because it's critical when you're considering whether something is a constitutionally protected communication about an off-label use, that you draw some reasonable, meaningful, bright lines about what can and can't be disseminated. For example, focusing on the dissemination of a peer-reviewed article. If you provide it, that in and of itself should be sufficient. The article speaks for itself if it's a published peer-reviewed journal article. It may very well be that there is other research, perhaps company-sponsored, perhaps independently sponsored, perhaps done by competitors, that tends to show a different result using a different patient population or applying a slightly different methodology. The responsibility of the pharmaceutical company should not be to pull together a bibliography of every piece of research that's ever been done about the article in order for their disclosure to avoid being deemed misleading and to trigger criminal penalties.
Paul, let me say a word about this First Amendment. You know, not all speech is protected, and again, I like to come back to the facts. In the Neurontin case, there were marketing assessments that the company did, signed off by the president of Warner Lambert and the president of Park Davis. The recommendation, which was a paragraph, like an executive summary at the beginning of those marketing assessments, called for the publication of clinical trials only if they had positive results. So when you talk about scientific exchange and the practice of medicine for a number of years now has been heading towards evidence-based. That means physicians need to rely on the evidence, what's published in the medical literature. But when it's corrupted because these companies suppress negative information or design a trial in such a way that it has a favorable outcome, or in the Neurontin case, that we now have documents from 1998 to 2004 in the class action litigation I'm working on, and we see both Warner Lambert and Pfizer suppressed 7 negative clinical trials for nociceptive pain, 4 negative trials for neuropathic pain, 2 negative trials for migraine, negative clinical data from the epilepsy trials in 1992 on bipolar. And this is just astonishing to me that the evidence pointed out to them by the FDA in 1992 that some of their subjects were experiencing suicidal ideation and suicide and severe clinical depression. FDA approved it for the patient population, epilepsy, and then in 1995, they go out and they market it for bipolar disorder. They hire physicians, pay them $500 for a teleconference to promote it for bipolar in the very patients who have depression. Then Dr. Pandy, an employee of Park Davis, writes an article that they put in the medical literature talking about the epilepsy trials and how it improved mood, but no discussion about the suicidal ideation. And then Dr. Pandy does a double-blind, placebo-controlled trial in 97. It's found to be negative. They don't get that out until the year 2000. But in the meantime, in that period of time, they're out there conducting these CMEs, promoting it for bipolar disorder. So the First Amendment doesn't protect all speech. And if you're going to have this scientific exchange between physicians, and Paul, you're a physician, physicians don't have time to sit there and read all the package inserts or read all the medical articles. What did we hear the other day, that there are 11,000 prescription drugs on the market? How can physicians, even if you specialize, how can you be familiar with all the adverse effects of those medications? You've got to rely upon, what they rely on are abstracts that are out in the medical literature. And if that's been polluted or contaminated by the drug companies, then we don't have, how can we practice evidence-based medicine?
As you can see, there is, the government believes that these cases are all driven by bad facts. On the defense side, we are equally firmly convinced that many of these cases really do involve the dissemination of information that is just information. It's truthful, non-misleading information, perhaps not yet approved by, or not by definition here approved by FDA. That raises what I've come to call the Copernicus problem. The Earth has always revolved around the sun, well before that was scientifically demonstrated, and the statement that the Earth revolved around the sun has always been true, regardless of whether or not the government approved that statement. And it's an important point to keep in mind. Many statements are true, even if they've not yet been blessed by the government. What I'd like to do is move on to a third really critically important subject here, which is this, that we've been talking for the first half hour or so of our discussion about the Food, Drug, and Cosmetic Act and a bit about the state prohibitions on the underlying speech itself, on the conduct of promoting off-label. It is equally important in our current environment that really, because of Tom Green's efforts, that the False Claims Act, the Federal False Claims Act, and now the numerous state False Claims Acts are being used as a vehicle for the civil prosecution of off-label promotional conduct. And the argument, as Tom very nicely laid out, is that if a company promotes a drug for an off-label use, that may cause, for various reasons, the government, either federal or state, to pay out money that it otherwise wouldn't have paid out. That's the kind of colloquial version of how a Food, Drug, and Cosmetic Act or off-label promotion violation arguably violates the False Claims Act. And it's these False Claims Act settlements driven by whistleblowers that are really causing much of the activity that you've seen in this area over the last 7 or 8 years. And I'd like to pose a couple of questions to both, perhaps maybe first to Susan here. I am quite frankly confused, a decade into this, as to how a violation of the one statute, the Food, Drug, and Cosmetic Act, can be morphed into a violation of the False Claims Act. I can appreciate if a drug company tells a doctor to lie about the patient's diagnosis. Drugs approved for diagnosis A, the drug company comes in and says, you know, doc, you're not going to get reimbursed if you say the patient has diagnosis A, so why don't you lie and say it has diagnosis B, for which you'll get reimbursed. I appreciate the problem there. But when the drug company, even let's assume it's promoted a drug for an unapproved use, if the claims form that the doctor submits to Medicare or Medicaid has the drug and has the diagnosis, what's false here?
Well, there are a couple of different prongs that we use to establish that for the Civil False Claims Act. One is the definition of covered outpatient drug. Medicaid only pays for drugs that are either FDA approved or where there's substantial, there's medically accepted indications, and that's a defined term which includes these compendia that give support to the drug. So that if a claim is submitted for a drug that is not covered, that is, by definition, something that cannot be paid. Now,
But let me just interrupt. But suppose that's evident from the face of the claim. You know,
it's never evident from the face of the claim.
Okay, so doesn't that get to another element, which is materiality? If the government cares, says we don't want to pay for this particular use or that particular use, why don't they just ask on the claims form, what is the use for which you're prescribing? And if it's one that they don't want to pay for, they don't pay. Why is this a fraud issue?
Well, it's a fraud if there are a couple of components to that. One is, for example, if the sales representatives are marketing the drugs with false and misleading statements to the physicians, then the physician the entire structure of our system is based on the concept, the framework, that physicians make independent judgments, and they make independent judgments based on truthful information. If they are fed false information on which their prescribing decisions are then made, our argument is that they have been caused to submit something they otherwise wouldn't have because of the false statements by the sales representative or the drug company. A second prong into that is if you have, and I'm going to mix a little apples and oranges here, kickbacks, for example, because often we find they go together, the false statements in the promotion together with payments to physicians. That's considered fraud on the physician, and our theory is that that causes a fraudulent statement by the physician. In other words, again, conduct which otherwise would not have happened. This claim would not otherwise have been submitted, and we don't intend to pay for claims that are either caused by false statements or caused by fraud. So it's a two-step process. I will say this. From my standpoint, it's easier to prove a criminal case, even with our burdens, and particularly the misdemeanor, which is a strict liability misdemeanor, than under the Food, Drug, and Cosmetic Act, than it is the civil case, because the civil case has the additional level of proof of submission of a false or fraudulent claim. So, and while there is also a civil component to the Food, Drug, and Cosmetic Act, which is disgorgement, basically, there are different remedies here that are available to us. And I do think the Civil False Claims Act is a harder proof burden for us in some ways, because there are extra layers of things we take on than we do in the pure criminal or Food, Drug, and Cosmetic Act setting, because that statute was designed for this conduct.
Susan, I'd like to explore in greater depth, and we just have a few more minutes left here, this point that you made about the physician being of course, the intermediary in all of this, and certainly you're all familiar with the learned intermediary doctrine under product liability law, under which physicians are presumed to be learned and knowledgeable, and you know, I have a serious question here as to how, under the False Claims Act, the government can argue that physicians are you know, improperly influenced by drug reps, and yet in other contexts are presumed to be learned and therefore presumed, I think, to make knowing decisions. But I wanted to bring Paul Greenberg back into the discussion here, because the details really matter here. And I wonder if you could just talk for a minute or two, Paul, about the kind of databases that you have access to. You know, how do we, you know, we talk at an abstract, at a legal level, we talk at a factual level, you know, statements A cause statements B, but you have the ability to delve into Medicare databases, Medicaid databases, trying to analyze this question. I wonder if you could just talk a little bit more about that process.
Sure. I mean, I mentioned in my introductory remarks that we're not yet at the point of having electronic medical data in a broad sense. At some point down the road, that might be a future database that we would turn to for further assessment of this kind of question. What we do have access to is basically compilations of the various claims data that are submitted, claims that are submitted either to Medicare for reimbursement or Medicaid or in a private sector setting. And whereas it is the case, or I should say it is not the case, that for the most part, claims themselves for prescription drugs are coded with ICD-9 diagnoses attached to them, the fact that you have typically in these databases, and I should say that these databases include millions of covered patient lives from which to draw and glean information, the fact that you have all that allows you to understand a relationship between the prescribing patterns that patients are faced with in comparison with their diagnostic histories. And that is a rich source of data. It's not perfect in the sense that we don't have complete understandings of all that went on in the physician's mind as he or she went to prescribe the drug. There are a lot of idiosyncratic factors that may not appear in terms of actual claims as they're written, but it gives us a lot of guidance, a lot of insight into what that diagnostic context was in which the prescription was ultimately forthcoming. And that matters. That matters a lot, as I said, in trying to understand how much off-label use there was, and of that off-label, what was the pattern of off-label. Just by way of example, one might arguably consider off-label use that was the first line of therapy for that off-label use differently compared to, say, a second or third line of therapy for that off-label use. So, for example, if in fact a particular prescription was forthcoming after a physician tried but failed to reach patient management, symptom management with 2 or 3 other drugs prior, that situation might be understood differently from the consequence of the off-label promotion perspective compared to a situation where a different patient was prescribed a drug off-label in a de novo context to a otherwise treatment-naive sort of patient. So not only how we understand on versus off-label, but even as we go to understand and bracket or unbucket, sub-bucket, create different subcategories within the off-label category itself, these kinds of rich data sources have every potential to shed light on what is really a very complicated situation.
Tom, we have just a couple of minutes.
Yeah, just
left.
chime in for 1 second. I think what what I'm hearing here is that in these False Claim Act cases, in product liability cases, and in class action cases, this is the defense. The plaintiffs or the government can't prove causation. They can't prove that the false and misleading market caused the doctor to write the script. And what Paul's just talked about is looking at the databases, for example, Medicaid, looking at the off-label script and looking at the diagnostic code and trying to match them up to see if in fact the script was for the off-label indication. There is also a database. These databases are Wolters Kluwer, Scott Levin, Verispan. There's a database. The drug companies spend billions of dollars for this data, and it tracks prescription uses. And so they'll buy the data and they'll look at it and they'll say, all right, 15% of the Neurontin is prescribed for bipolar, 22% for neuropathic pain. And they base and they model their business plans on this data that they purchase. So if that data is good enough for the drug companies to market the drug and draft up their business plans, it should be good enough for the government to use and for the private enforcement to use to prove causation. In other words, to establish that 22% of the scripts were for bipolar. Those 22% of the scripts started after the marketing bipolar events hit the calendar. Prior to that, if you look at the prescription data, the use data from Wolters Kluwer, there were no bipolar scripts. So that's how we prove causation in these cases.
Paul, can I say,
I just want to
yeah.
to find out if we have a few minutes left, we have maybe 5 minutes left. Are there questions from the audience? Yes, please.
Yeah, first of all, it seems to me that there ought to be some process to have FDA approval of off-label use of drugs from a consumer standpoint. I know I'm a judge, but also a consumer. There ought to be some kind of a procedure to do that, in my opinion. The other question I have is that I assume the industry isn't totally self-insured. There must be, I would assume there's insurance companies covering these pharmaceutical companies. I'm surprised that their insurance contract would cover off-label uses of FDA-approved drugs.
I can at least quickly try to respond. And, for better or for worse, at least in the drug area, FDA approval is really bipolar. You're either approved or you're not approved. And there is not a kind of gradation, if you will. The FDA is not involved in the business of kind of rating the validity of claims that don't rise to the level of a formal claim. As to insurance, I'm not aware of any insurance contracts that cover alleged fraud or criminal conduct. So to my knowledge, all of these cases product liability cases tend to be insured, but government investigations are not. I don't know if anyone has a different understanding on either point. Another question?
To clarify the insurance question, was it relating to the insurance that a drug company would carry to cover its potential liability here, or whether it was going to reimbursement of the drugs for patients who...
No. I'm surprised that they could even draw up an insurance contract and predict, what the premium should be and so forth if off-label uses of drugs are allowed. Mm-hmm. In other words, that the company would be covered if off-label use of a drug is allowed.
I don't have a whole lot to add to that.
I think they're self-insured, at least from what we've seen.
And I'd like to add one point. There is a mechanism. It's called the Supplemental New Drug Application, and at any time, companies can submit a supplemental application to get FDA approval for an indication. The issue is, do they have a financial incentive to do so? In the Neurontin matter, gabapentin was moving toward the expiration of its exclusive period. If they had obtained another indication, it would have been the generic manufacturers that would have benefited as much as Warner Lambert.
Judge Saris referred to this in the sharing case as, why buy the cow when you can get the milk for free?
There's another, on that note.
I had a self-help observation for
overburdened trial judges, because like the physician, I want to understand the implications of what I'm doing, Mr. Kalb, and also like the physician, as a judge, do not want to be caused to do something based on false statements or fraud. What I found based on my experience in complex and coordination litigation, because of all the conferences we've gone to about the ginned up literature, the American Association of Law Schools does not require learned professors who write articles to disclose their financial support. So I simply move the burden to the trial counsel, who in all states has an obligation as an officer of the court not to mislead the court. And I request, and I've not had them oppose it under work product, privilege, or other things, to vet the literature and to present to me in writing their investigation concerning the authorship and background of this literature upon which they ask us to rely. Because I recently had a case with a lawyer, I was faced with the motion to strike large portions of a brief because the zealous but slothful advocate indicating his professor was a PhD at Stanford, a master's at Berkeley, and a fellow of the American Board of Toxicology, Judicial notice established. The guy had never been to Stanford, never been to Berkeley, and was under a permanent injunction from the American board. I believe that if trial judges are aggressive in this manner, we won't be a victim of false and misleading conduct. I wonder if you think there are ethical implications or if that's right or wrong. I think it's good, strong trial management, but I don't know what the advocates feel about that practice of the trial judge, putting those burdens upon the lawyer who's proffering literary and professional written evidence.
We think of that as the deterrent effect. I mean, anybody who hears about what you've done is never going to do it again.
Yes.
You have an obligation to tell me your adverse cases in a brief. And you said, well, why do the drug companies have to provide a bibliography? Why shouldn't they provide a bibliography, or at least a readily accessible link that tells the doctor, if you want to find out as much as can be found out about this with due diligence about this particular use, go to this website, click on this link, and it's all laid out. I mean, isn't that the equivalent of what you have to tell me as a lawyer if you're in front of me before a judge? I mean, I really question why you say, do we have to provide a bibliography? Why shouldn't you provide a bibliography?
I think the answer is what is, if the rules are clear, then you need to play by the rules. As a lawyer, I have an obligation to obviously disclose controlling authority against the position that I'm taking in a brief, absolutely. The way that line's been drawn, I don't necessarily have an obligation to disclose a case going the other way if it's in a different jurisdiction and isn't otherwise controlling. If I'm litigating in state court in Massachusetts, and there's a California court interpreting a California statute that is, that they're both part of the same uniform code, I don't have an obligation to disclose it. My adversary may very well bring that up in their brief, and so it might be prudent to disclose it, but it's not the same obligation as I would to disclose contrary Massachusetts authority. That's where the line has been drawn. We have to play by those rules. Here, the lines haven't been drawn in statute or regulation. What you have is a debate about, is it misleading? When a pharmaceutical company walks in and hands over a peer review article, if there's a background expectation that everything that's been published pertinent to that topic is also being disclosed, then failing to include those studies in a bibliography is absolutely, would be misleading. If the background expectation is that the burden's on the doctor to go find that information, then it's not misleading. The difficulty that I think pharmaceutical companies are facing is that they're being prosecuted for conduct that happened over the last 6 years, 7 years, 8 years, depending on the time frame we're talking about, when there was no clear expectation that they would be obliged to provide that information. And so now ex post, we're looking back and saying, oh, well, even though it was, the method was disclosed in the study and this was there, you didn't disclose these other studies that would have made clear that there might be some limitations on that, so then that's a crime. So my view is that I think from a burden perspective, you shouldn't have to disclose a bibliography. If the Congress and the FDA in their wisdom established a regulatory regime that requires the bibliography, then companies have to step up to the plate and follow it, absent litigation to establish a defense that holds otherwise. That hasn't been done. Part of what is so difficult in this area is that, even though the stakes are so high, the rules are very are very loose and poorly articulated. And the problem then is always, if a company took it upon itself to provide the bibliography, they face sort of the Good Samaritan problem right now under the current legal regime, because if they miss a study, then by disclosing some but not all, I think you've got a much stronger case that what they've done is misleading. It would be much easier to draw a bright line rule saying just hand over the study, don't misrepresent orally what it contains, and leave it to someone else to determine whether there's something else
One
out
thing
there.
I have learned from my years of appearing before judges like you is not to exceed time limits. Our time is up. I think all